Hello friends, welcome to Let's Crack UPSC CSE English, and this is me, Dr. Sidharth Arora. My friends, in the previous introduction to this channel, I had told that since we had received n number of grievances and n number of complaints and in fact requests or whatever you want to call it, that several of our UPSC civil service aspirants have not been able to understand the combination of Hindi and English language as we were continuing our teaching in the Let's Crack UPSC CSE channel. Hence, we have on popular demand launched a channel which is going to deal with your entire UPSC CSE syllabus, but only and only in English language. Now, on the popular demand and on the basis of the large number of subscriptions and the large number of likes that we have received on our announcement videos, we are launching this channel right now. So this is now with one mission and with one mission only, and that is that we will crack UPSC CSE but using English and only English as a medium of instruction over this channel. So, step number one, for all those students who would like to understand UPSC CSE or my syllabus or those by the several educators that are present on this channel in two languages. For those who would like to understand in the combination of Hindi and English, please switch over to the other channel, the channel that is Let's Crack UPSC CSE. Only those aspirants who are comfortable in understanding English and only English, please continue on this one. The other ones, please switch over. The plan over here is that we want to send across our instruction, send across our education, and make sure that everyone gets benefited out of Unacademy channels and Unacademy videos, regardless of whether or not whether you understand Hindi or you don't understand Hindi. So, on popular demand, we are launching this channel and we are starting today with the first core chapter of polity, and we are doing what is called as power of judicial review. My friends, I would like to make a commitment right now. If you follow these channels and if you follow my videos the way I am teaching you and the way I would like you to understand, then I am committing this that at the end of this video itself, today, right now, at the end of today's video, you will become practical champions in understanding what is judicial review. And in the same vein, I can say that whenever I finish off a polity topic, you will become champs in that, provided that you follow every word that I say, provided that you revise every word that I say. My plan is a single point agenda is that you should become champions in the subject and you should have a realistic chance of passing this exam. Now, most of you must be knowing me. If you don't know me, this is me. I'm Dr. Sidharth Arora. I'm a practicing advocate in the Supreme Court of India, and I have been teaching UPSC aspirants for the last several years. Also, I'm the author of several books which are available on Amazon. These are available on constitutional law, on criminal law, on polity, forensic genetics. You might search with my name on Amazon and you'll get certain books as it is. Now, give me just 2 minutes of your undivided attention. It is very crucial. My friends, I'm making this video on the first day of the month of March. If I count the days, it is only the month of March, it's only the month of April and the 30 days of May. My friends, this is make or break time. If you do not take action now, I'm afraid it is going to be too late. Don't be too late, don't be too slow, don't be too lazy about taking a decision. If you think and if you are even reasonably assured of this fact that yes, sir, I need some kind of mentoring, I need some kind of specialized training, my friends, the answer is right here. The answer here is that Unacademy subscription will bring to you not one educator, my friends. Mind you, you will have educators from prelims all the way till optionals. You will have several educators from all over India, regardless of your language problem. Mark my words, regardless of your language problem, since most of these courses will be taken in bilingual method. You will have all subject training and we will give you a supportive hand. See, in God's own world, there cannot be anything called guarantee. There cannot be anything called guarantee. But if you join an Academy subscription, sitting at your place, sitting at your home, combining with your work, combining with your responsibilities towards your family, you can have an awesome preparation for your exam. This is what is going to be you will be getting on this channel, that is on UPSC CSE English. There will be daily live classes if you take an Academy subscription. You will have live tests and quizzes which will give you an exam-centric preparation. There will be structured courses. I have always noticed people study, but people do not know the structure of how to pass this exam. You will also have unlimited access. You can download these videos. You can watch them at your sweet disposal whenever you have time, whenever there is a liberty of time, minus your work, minus your family responsibilities. Life is not going to stop. You have to prepare for this exam while you are doing the rest of the things also. You will have the top educators in India teaching you their own particular subjects. They will be teaching you. These are the best of the best subjects. Experts, please understand and try and compare this to an offline class in which you will have one teacher, at maximum two teachers for a subject. Here you will have so many educators from all over India, from the length and breadth of this country, and they will help you achieve a realistic chance of passing this exam. You will have many special classes. For example, I have taken special classes and I'll continue to take many classes. For example, the recent development in Jammu and Kashmir, I hope you remember the abrogation of Article 370. These are special classes. You don't even need to study anywhere else. These are classes which will be available to you. All of these and much more will be available if you take an Academy subscription. The good part here is it is very economical. A 1-year course is available for all my friends who are appearing in 2020. That is the exam on 31st May 2020. My friends, listen carefully. This course for 2020, I will be suggesting you a 1-year course. 1-year course will be available to you at merely 40,000 rupees, but use my code. Use my code SID10, SID10. SID10 will give you an immediate 10% discount, and at 36,000, my friends, welcome to my courses. In a better option for those students who are already thinking of appearing for this exam in 2021, or those of my friends who are in college, you are very lucky. You have got 2 years for a substantial preparation. If you are preparing for a 2 years agenda, then my friends, you're very lucky, because the 24-month subscription is available for merely 48,000 rupees. But the moment you use my code SID10, SID10, you will get a 10% discount, and it is only 43,200. Do some mathematics, churn some numbers. 1 year is available for 36,000. 2 year is available for 43,200. Merely 7,200 here and there. So take your decision. You're a wise gang of students, and I'm very sure that you're very serious about your career. Take a wise, reasonable decision, but take it now. Now means now. Don't make it too late. If it's too late, it's never. So, choice is yours. It's my duty to tell you on this part. Today we are doing judicial review. There are rules of the game. The rules of the game here is, I would like you to be very seriously involved in this class. So take a register, take a notebook, take a piece of paper, sit down as if you are watching or you are attending an offline class, and I am promising you, you will come out champs in this subject. So be very careful. I will go slow, but we will go thorough. First core topic of polity, that is, we are discussing what is called as powers of judicial review. Hold on. Step number 1. Take a deep breath, relax and understand this. First of all, to understand judicial review, there is some amount of background work that you have to do, some amount of background study that you have to do. So what do we have to do? First, I have to find some definitions. In law, in constitution, in the fields of interpretation of law and so on and so forth, first we have to define. Why is it so crucial to define? Because your definition may not be the definition as given in the statute books or the constitution. the way we talk in normal English language is not necessarily having the same meaning or the same interpretation as given from the Constitution. Fair enough. So what do we have to do? So first we will have to find definition. Now there is a rule here. Now what is the rule here? The first rule that all of you must make sure that it becomes a part of your living memory is number one. Please write it down in bold letters, and it says, in law, there are no synonyms. What did I say? In law, there are no synonyms. What does that mean? So in law, a woman is not the same as a female. A female is not the same as a girl. I hope you are understanding. When I say woman, okay, when I say female, when I say a girl, or for that matter, I use the word feminine, it is not the same in the eyes of law. In law, if the constitution makers or the parliament or the legislature uses the word woman and uses the word female, there must be a reason for that. It is not, as you say, we were enjoying writing it. No, this is not English literature. This is law. So when you are writing a word in law or in the constitution, if there are two different words, then there were two different words for a particular reason. And therefore, you should not have synonyms. So point, this is step number one. You have just taken the first step in understanding constitution and understanding law. Please remember, in law, there are never any synonyms. Every word which is different is there because of a particular reason. So my definitions in law have to be very, 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 very strict. This has to mean only this. So first we have to strictly define the word state. Now where will I look for the definition of the word state? Your definition of the word state could be different. My definition of the word state could be different. Somebody else's definition of the word state could be different. So where do I go and seek the information regarding the correct definition of the word state? So for rule number 2 is that I have to believe in only one authority, and that one authority is the Constitution of India. So what did I say? The final authority, or the authority which is going to define everything for me, is called as the Constitution of India. So why am I so interested in reading the Constitution of India? Because the Constitution of India is the fundamental law of the land. Please jot it down right now. So what is the Constitution of India? Constitution of India is the fundamental law of the land. Several amongst you must be engineers, or you must have some kind of science background. Have you used the word fundamental someplace? Yes, I'm sure you must have used. In physics, they say very often, they say there are fundamental particles. I'm sure that you must be knowing of that part. So for electrons, protons, neutrons are fundamental particles. So why are you telling us, sir? Why are electrons, protons, neutrons called as fundamental particles? Because all other matter emerges from these fundamental particles. Repeat the line. What did I say? All other matter, everything else emerges from the combination of electron, proton, neutron. In the same way, I said, in the same way, every other law, every other action, every other policy, every other amendment by the government or the parliament must be in the spirit of the Constitution of India, must be derived from the Constitution of India. Hence, Constitution of India is described as the fundamental law of the land. Is this picture clear? I said Constitution of India is the fundamental law of the land, since every other law, every other government action, every policy, everything must be in the spirit of the Constitution of India. Hence, we will look for everything, including the definitions of terms, from the Constitution of India. This is rule number 2. So rule number 1 was, in law there are no synonyms. Rule number 2 here is that we are saying that the Constitution of India acts as the fundamental law of the land. So where will I look for the definitions? I will look for definitions for the word state from Article 12. Now, what is so interesting about Article 12? Article 12 is a part of Part 3 of the Constitution. So, why are you telling us? Because Part 3 of the Constitution deals with what are called as fundamental rights. So, why are we saying? So, why are fundamental rights called as fundamental? Question number one. Why are fundamental rights called as fundamental? Fundamental rights are called as fundamental because fundamental rights are guaranteed by the Constitution of India, which I just told you is the fundamental law of the land. I hope you are now understanding. My constitution is guaranteeing to an individual some rights. These rights are guaranteed by the constitution, and that constitution we have already understood is the fundamental law of the land. Hence, those rights are called as fundamental rights. Where are these fundamental rights written? These fundamental rights are written in Part 3 of the Constitution. I'm sure you know a bit of this, that your Constitution is divided into parts and every part has several articles. In the Part 3 of the Constitution of India are mentioned what are called as fundamental rights, which start from Article 12 to Article 35. These are guaranteed by the Constitution of India. I hope the story is clear. So let's start creating a definition. Let's start creating a definition. I don't want you to memorize anything until unless you understand what I am trying to tell you. Let us define, but let us create the definition. What are fundamental rights? These are rights which are guaranteed by the fundamental law of the land. Sir, what is the fundamental law of the land? Fundamental law of the land is the Constitution of India. Where is it written? It is written in Part 3 of the Constitution. Part 3 of the Constitution starts from Article 12 to Article 35. A very important question comes to my mind. Sir, why do we need fundamental rights? I don't want fundamental rights. Why do you want fundamental rights? My friends, to understand what is fundamental rights requirement, let us understand the definition of the word state. So, I am looking at Article 12 to Article 35 of the Constitution. In other words, I am looking at the Part 3 of the Constitution. So, I am very happy. Okay. I am very happy. I have got certain rights guaranteed. Who am I? I am an individual. I am an individual. I am an individual and I am very, very happy. Look, I am smiling. Okay. So I am smiling. Why am I smiling? Because I have got fundamental rights. A question arises that why do you need fundamental rights? I need fundamental rights because I am an individual, but there is something called as state. I am an individual and there is something called as state. What is state, sir? State includes the government of India. Loud and clear, wherever you are sitting, shout it out. It includes, number one, the government of India. Number two, the parliament of India. Number three, the government of the states. Number four, the legislature of the states. And number five, any other local authority, either within the territory of India or under the control of government of India. Don't you try to run away from this definition. You have to ensure that it seeps deep inside your brain. Pay attention to what I'm trying to tell you. What is Article 12 defining? Article 12 is defining the definition of the word state. What does state include? State includes government of India. State includes Parliament of India. State includes government of states. State includes legislature of the states. State includes any other local authority within India or under the control of the government of India. So, sir, is the union government, that is Narendra Modi's government right now, is it state? Yes. Union Parliament is state? Yes. Vidhan Sabha, State Legislative Assembly, is it state? Yes. Chief Ministers of the states? Yes. Army, state? Yes. Police, state? Yes. CBI, state? Yes. I hope you are understanding. In other words, state is a mighty powerful thing. So, in a nation, please pay attention. In a nation, for example, let's take India. In a nation, there are two components. One, me. Who am I? I am an individual. And there is something called as state. State is mighty powerful. The entire parliament, the entire government of India. I've just defined. What is that? Government of India, Parliament of India, government of states, the legislature of the states, any other local authority within India or under the control of government of India is state. Now the point here is a very important problem. The problem here is that state is very powerful. State is hugely powerful. So the founding fathers of the constitution thought, Dr. Ambedkar thought, and the rest of the Constituent Assembly thought, in comparison, in comparison to the state, the individual is a very weak thing. The state can any day destroy this. The state can any day destroy the individual. Yes, it's a possibility. Such power. Then who will ensure that the individual is not destroyed? Who will ensure that the individual is not destroyed by arbitrary use of power? Use this word, everyone, loud and clear. Wherever you are sitting, say this word. Who will ensure that the state will not destroy this individual by an arbitrary use of power? There must be somebody protecting him. Who is protecting this individual? This individual is protected by the most powerful element in the nation, and that is the Constitution of India. Yes, state is very powerful and the individual is very weak. But who is most powerful? The most powerful is the Constitution of India. This is the phenomenon called as lex rex, called as law is the king of kings. So, Dr. Ambedkar and the founding fathers of the Constitution are telling, dear individual, don't be nervous, don't be scared. Yes, we understand state is very powerful, but you will be protected by the most powerful element, and that most powerful element is the Constitution of India. So the Constitution of India is telling this individual, dear individual, don't be scared. The state will not be allowed to destroy you by, use the word, arbitrary use of power. And that guarantee to the individual is called as fundamental rights. So the individual will be ensured human existence. I am again repeating, the individual will be ensured human existence by the presence of these rights called as fundamental rights. So these fundamental rights are given to the individual against the state. Very important. Fundamental rights are not between you and me. Fundamental rights are available to me against the state. Are we clear? So let's have one final time a definition of fundamental rights. And my friends, if you understand this fundamental rights, tomorrow you are capable of arguing in at least the high courts of your state, if not the Supreme Court. So just understand this part and understand what I'm trying to tell you. Let's have a complete definition. So what are fundamental rights? Fundamental rights are rights which are guaranteed by the Constitution of India, which is the fundamental law of the land. These rights are available to an individual against the state. These rights are written in Part 3 of the Constitution of India, which starts from Article 12 to Article 35 of the Constitution, and these rights will ensure that you have human existence. Therefore, these rights are called as fundamental rights. If you miss one comma, if you miss one alphabet from here, you are not giving a complete answer. I hope you now know how to study polity, how to study constitution. There is a method to become a champion in this subject. Make sure that you know. So we will now look at Article 12 of the Constitution. If a question comes to you in the civil services examination, Which right is given in Article 12 of the Constitution? You will say no right is given. No right is given in Article 12 of the Constitution. Article 12 of the Constitution is merely giving me the definition of the word state. Sir, what is state? State is Government of India, Parliament of India, Government of State, Legislature of the states, and any other local authority with this, either within India or under the control of Government of India. Is that picture clear? If that picture is clear, my friends, you have taken one giant step in understanding polity. Fair enough. We continue. So now I am wondering whether Article 13 of the Constitution will give me some fundamental right or not. Fair enough. So Article 12 was only giving me definition. So I was wondering whether Article 13 will give me any right. No. Article 13 is also not giving me any right. That's very surprising. So I'm looking at Article 13. So I was looking at what is Article 13 giving me in that case. Article 13 is giving me the definition of the word law. Wow. Can you imagine this part? That we are not only, these words are so commonly used by all of us. We commonly use the word law and state and so on and so forth. But from now onwards, stop doing this. Why? Because every word needs to be defined. And who will define that? The best definition will come from the Constitution of India. Fair enough. So how will we define the word law? First, make no mistake about it and understand what I'm trying to tell you. There are two possibilities. One, I define the word law. What did I say? Choice number one, I define the word law. Choice number two, I define what is not law. Has it seeped inside? Let me explain this to you. So let me take a hypothetical structure. Then you'll understand this. Nobody in this world will explain you that simply. So please take the full opportunity of understanding what I'm trying to teach you. You will be genuinely and giantly rewarded. Please pay attention, right? So I'll take you to a universe, right? I'll take you to a world in which, this is a hypothetical world. There are only two colors in this world. I'm just taking you to this world. One color is black and one color is white. Imagine every other color is gone. So we are now living in a world which is black and white, right? Now I am asking you a question and I am asking you, my dear friend, please define the word black. So how will you define it? I'm sure most of you would say this, and that's the correct answer. You will say, sir, black is a color which is not white. And in the same breath, if I ask you, what is black or how do you define white? Then you will say, so white is a definition, that white is a color which is not black. In other words, I am not defining the word white and I'm not defining the word black. I am defining what is not white and what is not black. So what will be the definition of white? What is not black? What is the definition of black? What is not white? And so on and so forth. Such definitions are called as negative definition. So what is very surprising here is Article 13 is not defining the word law. It is giving me a negative definition of the word law. In other words, it is telling me what is not law. I'm repeating, it is not telling you what is law, it is telling you what is not law. Now understand this. Now there are some words I want you to memorize, right? And if you understand this, cool, right? You'll be understanding this far better. So how does Article 13 define the word law? First of all, please get into your back of your mind that we are defining it in a negative form. So there's a negative definition. So everyone will say as I want you to say. Start shouting. I'll say. So it is saying any order, say the word, wherever you are sitting, any order, any action, any legislation, any amendment. I'm repeating this word. What are the four words? I said any order, any action, any legislation, any amendment. I hope everyone knows what is this. Order, you can understand. Action by the state. So I'm talking by the state, right? So any order, any action, any legislation, any amendment. Which amendment, I hope you know, amendment is any change in the constitution. Any order, any action, any legislation, any amendment, which, and utilize three words. Violates, say the word, violates, abridges, say this word, abridges, or contravenes, So we'll repeat these words. So repeat everyone after me. Any order, any action, any legislation, any amendment which, say the three words, violates, abridges or contravenes anything in part 3 of the Constitution. Anything in part 3 of the Constitution. What is part 3 of the Constitution? Article 12 to Article 35, which deals with what is called as fundamental rights. So I'm repeating this one finally now. Get ready for this. I said, any order by the state, any action by the state, any lawmaking, that is legislation by the state, any amendment by the state, which violates, abridges or contravenes. By violates, abridges and contravenes means you're not allowed to even touch by a centimeter. What? You're not allowed to even touch any centimeter. Entire part 3 of the Constitution is not law. What did I say? It is not law. So any order, any action, any legislation, any amendment by the state which violates, abridges or contravenes anything in part 3 of the Constitution which deals with your fundamental rights is not law. It is not legal. It is not valid. So, Article 13 is not telling you what is law. It is telling you what is not law. It is saying state shall not make any law which takes away, that is violates, abridges or makes a contravention of this clause to the extent of contravention be void. You don't know how to read the Constitution, but I have simplified it to you. Loud and clear, say this line. Any order, any action, any legislation, any amendment by the state which violates, abridges or contravenes anything in part 3 of the Constitution is not law. It is not law. So what will you do, sir? In case the state makes such a law, in case the state decides to make such a law, what will you do about it? In case the state makes such a law, somebody has to protect. Who will protect that? That protection will be made by the Supreme Court or by the High Court. Who will make that? That will be made by the Supreme Court or the High Court. What will they do? If the state makes any order, any action, any legislation, any amendment which violates, abridges or contravenes anything in your fundamental rights, the Supreme Court or the High Court will declare that thing as ultra vires. What does ultra vires means? Ultra vires means it is not in the spirit of the Constitution. What did I say? It is not in the spirit of the Constitution. The courts will declare it null and void and strike it down. They will strike it down. This power to declare any order, any action, any legislation, any amendment which violates, abridges or contravenes anything in part 3 of the Constitution and declare it as ultra vires, declare it as null and void and strike it down is called as power of judicial review. Perfect? I hope you are understanding. So what is Article 13 giving you? Article 13 is giving you the negative definition of the word law and describing the power of judicial review. I told you this specifically. Pay attention, put it in your head. I did not say that it is writing the word judicial review. It is describing the power of what is called as judicial review. So now you have solid, rock solid understanding of the topic, I'm sure. Part 3 of the Constitution deals with fundamental rights. Part 3 of the Constitution starts from Article 12 all the way till Article 35. Article 12 is not giving you any right. Article 12 is only defining the word state. Article 13 is also not giving you any right. Article 13 is defining the word law, but it is not defining it in a positive manner. It is defining it in a negative manner. It is saying that any order, any action, any legislation, any amendment which violates, abridges, contravenes anything in part 3 of the Constitution is not law. What will you do about it, sir, in case the state does it? In the case the state does it, then the Supreme Court or the High Court has got the powers to declare it as ultra vires, and if it is declared as ultra vires, they will be struck down. In other words, they will be declared as null and void. Please remember, the power of the judicial review has been given to the courts, and it is available both to the Supreme Court and the High Courts of the state. Make no mistake about it. I said these powers are available both to the Supreme Court as well as to the High Courts. Make no mistake about it. Where did we get this power, sir? Actually, historically speaking, these powers have been emerged from United States of America. Sir, that means it is written in the Constitution of USA? No. Even in the United States Constitution, the word judicial review was never used. Please understand, it was never used in the Constitution of USA also. However, there was a very famous case. It was called as Marbury versus Madison. Please remember, this is topper material questions. Okay, this is 24 karat gold preparation. If you are not able to understand this, then you are not able to understand this. But if you understand this, then you become toppers, right? There was a case called as Marbury versus Madison case in 1803, and Chief Justice of Supreme Court of USA at that time, that is Justice Marshall, he used this word, or rather he not even used this word, he actually explained it. He said that the judiciary has the power to examine the laws. What am I saying? To examine the laws. This examination of the laws which are passed by the legislature was the definition or the understanding of what judicial review is. So, what does Chief Justice Marshall say? That if there is a law which is found to be in violation of the Constitution, then such a law would be declared by the court as ultra vires of the Constitution. This is judicial review. Chief Justice Marshall has invented or innovated or interpreted what judicial review is. Remember what I am saying and write it on your walls with Nerolac paint. The word judicial review is neither written in the Supreme Court, in the Constitution of USA, nor is it written in the Constitution of India. In USA, Chief Justice Marshall, the Supreme Court of USA, interpreted it. In India, Article 13 describes the power of judicial review. The word judicial review is neither present in the Constitution of USA nor present in the Constitution of India. So what is judicial review? Judicial review is the power of a court to inquire whether an executive order or other official action conflicts with written constitution, and if the court concludes that it does, then they can declare it unconstitutional and void. I hope this settles this problem for a lifetime. You cannot forget this, and I'm sure the way I have explained it to you, it must have gone into your head. There are a couple of things that you should know. Is judicial review an absolute power? Is the court having practically unlimited powers with judicial review? The answer to that is not my answer. The answer to that comes from two very important judgments. One judgment is Kesavananda Bharati versus State of Kerala. I hope everyone knows this part. This is the landmark judgment which gave what is called as basic structure of the Constitution, and I intend to do it in a detailed topic when we come down some other day, when we make a proper video on basic structure of the Constitution. Kesavananda Bharati judgment had described that judicial review is also a part of basic structure. When it is a part of basic structure of the Constitution, it cannot be taken away by any amendment. It cannot be taken away by any law. It cannot be taken away by any order. It cannot be taken away by any action, including the infamous 9th schedule. If you have a bit of understanding, the 9th schedule was made by the first constitutional amendment which took away judicial review. And in a famous case of I.R. Coelho versus State of Tamil Nadu in 2007, Supreme Court utilized what is called as a retrospective application. We will do on this on a very big thing. Do you realize the importance of this date? What is 24th April 1973? 24th April 1973 has got two very important requirements, or two very important events for India. Number one, this was the date the great Kesavananda Bharati judgment came, and the second one was, of course, it is the birthday of the great god of cricket, Sachin Tendulkar. So either way, that you can keep aside. But for the time being, the Kesavananda Bharati judgment came on 24th April 1973. In the year 2007 came this judgment. IR Kohilo was the state of Tamil Nadu, and they utilized this judgment and applied it to an event which had happened on 24th April 1973, when the Supreme Court in this judgment said, under no conditions, regardless of whether it is written in the 9th schedule or whichever schedule, we don't care. There will always be judicial review. But starting from which date? Starting from the date 24th April 1973. What am I trying to tell you? If you put a law even in the 9th schedule after 24th April 1973, mark my words, after 24th April 1973, it will be open to judicial review. Judicial review cannot be taken away. It is a part of basic structure of the Constitution. In the words of the great Chief Justice Y.V. Chandrachud, who used this in Minerva Mills case of 1980, everything in India is under judicial review. So, my answer here, is judicial review an absolute power? Yes, sir. It is an absolute power. It cannot be taken away by any order, any action, any legislation or amendment. So, let's summarize. What are fundamental rights? Fundamental rights are guaranteed rights. These are rights guaranteed by the Constitution of India, and this Constitution of India is the fundamental law of the land. It is written in Part 3 of the Constitution, which starts from Article 12 to Article 35. Article 12 defines the word state. It is not giving you any definition, mark my words. Article 13 is also not giving you any rights. It is defining the word law, but in a negative sense. And mark my words again, it is describing the power of judicial review. It is not writing judicial review. Judicial review from 24th April 1973, that is Keshavananda Bharati judgment, is now a part of basic structure of the Constitution of India. Please remember, both Supreme Court as well as High Courts have got the powers of judicial review. This is how you study polity. This is how you write rock solid answers. Once you know your subject like this, you don't need to go to an astrologer. You don't need to ask anyone whether you're going to pass this exam. You're going to crack open, destroy the examiner. You and the examiner will be smiling and giving you your passing marks. In fact, you're making you a topper. That's how you study polity, my friends. And that's what I intend to do to my learners and my aspirants. If you want any mistake of your understanding of the subject, if you want any clarity, if you want to give yourself a realistic chance of passing this exam, I welcome you to join my courses on Let's Crack UPSC CSE English. Please save some money. Use the code SID10, SID10, and save some money. This is a very economical, very reasonable, very effective way of giving yourself a realistic chance of passing this exam. Until next time, God bless. Thank you. And in the words of Unacademy, let's crack it. Thank you.